We live in an age of AI, where information moves at the speed of light. But what happens when the very rules designed to protect what we say are put to the ultimate test? You see, there's this legal shield, created decades ago to protect civil rights activists. And right now, it's facing a threat it was never, ever designed to handle.
And when I say threat, I'm not kidding. Just get a load of this number. Between 2022 and 2023, the use of deepfakes in fraud cases shot up by 3,000%. That is just staggering. And look, this isn't some far-off sci-fi problem. It's happening right now. And it's not just about money.
Picture this. It's January 2024. Voters in the New Hampshire primary get a robocall. And the voice on the other end? It sounds exactly like President Joe Biden. And he's telling them to not vote, to save your vote. Of course, it was a complete and total fake. An AI-generated deepfake designed for one purpose, to mess with an election. This is a real-world example of this technology being used as a weapon against the democratic process itself.
So it really makes you wonder, right? In this wild new world where literally anyone can create a harmful, convincing lie, why does our legal system seem to give those lies so much protection? Well, the answer, believe it or not, doesn't start with AI. It starts way back, decades ago, with a newspaper ad and the fight for civil rights.
To really get what's happening today, we have to jump in the time machine and go back to 1964. We need to talk about a landmark Supreme Court case, New York Times versus Sullivan. This is the case. It's the one that created that powerful legal shield we were talking about, the one that protects so much of our public speech. And it's the reason why it is so incredibly hard to win a libel lawsuit in the United States. All right, let's just walk through how this whole thing went down. It all kicks off in 1960. When the New York Times runs this big full-page ad supporting civil rights advocates. That very same year, L.B. Sullivan, a city commissioner down in Montgomery, Alabama, sues them for libel. And at first he actually wins. An Alabama jury gives him everything he asked for in 1962. But just 2 years later, the U.S. Supreme Court steps in and changes, well, everything. Now the basis for the lawsuit. This is where it gets really wild. The ad had a couple of tiny factual mistakes in it. For example, it said protesters sang one song when in reality they sang another one. But here's the crucial part. The ad never, ever mentioned L.B. Sullivan by name. He sued them simply because his department, the police force, was being criticized. That's it. And this chart shows you exactly what the real strategy was. The Times made less than $5 grand from the ad. The Alabama jury awarded Sullivan $500,000, the full amount he wanted. And with other lawsuits piling up, the total was heading toward $3 million. So you see, this was never about getting a song title right. This was about using libel law as a financial weapon to crush reporting on the civil rights movement. Luckily, the Supreme Court saw right through it. They understood that if they let that verdict stand, it would create a massive chilling effect. Newspapers would become too scared to report on controversial topics. It would silence the press, and it would silence minority groups fighting for their basic rights. So the court made a choice. They decided that protecting dissent against power was more important than guaranteeing perfect factual accuracy in a debate.
So the court forged that new shield. They created the actual malice standard. And here's what it means in plain English. For a public official to win a libel case, they have to prove that the publisher knew what they were saying was false, or that they published with a reckless disregard for the truth. An honest mistake isn't enough. Even just being sloppy isn't enough. They set the bar incredibly high on purpose to make it much harder to use libel law as a weapon.
But remember, that was 1964. The world that the Sullivan decision was built for, a world of giant printing presses and just a few powerful media outlets, that world is long gone. Technology has completely rewritten the rules of the game.
I mean, think about it. Back in the 60s, publishing was incredibly expensive. You needed a printing press, distribution networks, only a few big players could afford it. Today, the cost of speech is basically zero. We're all walking around with a global publishing house in our pockets. The original fear was that you could silence a whole movement by bankrupting a few key newspapers. That economic logic just doesn't hold up anymore.
And this massive technological shift has created a very strange alliance. The very shield created in Sullivan is now getting attacked from both the political right and the left, though for completely different reasons. What was once seen as a sacred protection for speech is now viewed by many as a source of our modern information crisis. This really is the heart of it. We've gone from physical ink on paper to digital code. The very nature of what speech is has been transformed. And we're now trying to apply a legal framework from the 1960s, one designed for newspapers, to things like social media algorithms and AI. And it's creating tension all across the political spectrum.
So from the conservative perspective, the argument goes something like this. The actual malice shield no longer protects the little guy. Instead, it protects powerful and what they see as biased institutions. They argue it allows big media companies and big tech platforms to publish damaging falsehoods about them with very little fear of being held accountable, which in turn distorts the whole public conversation.
Justice Neil Gorsuch really captured this critique perfectly. The original logic was to protect dissenting voices from being crowded out. But as he points out, in a world where everyone already has a platform, a soapbox in their pocket, it's not so clear that these old protections, designed for just a few powerful publishers, still make sense. Now, the liberal critique is a bit different. It's less of an attack on the original Sullivan decision itself and more of a deep anxiety about what it means for us today. The worry is that the same high bar that protects legitimate journalism from being sued into silence also protects the flood of dangerous disinformation about elections, public health, and extremism that flourishes online. It makes it nearly impossible to hold the people spreading these harmful lies accountable. So what you end up with is this deep, awkward irony. A rule that was created to protect a vulnerable movement from powerful people is now seen by many as a primary reason we struggle so much to fight harmful falsehoods in the digital age. In a way, Sullivan has become the legal foundation for our modern tolerance of falsity.
And this brings us right back to where we started, to those AI deepfakes. With this legal landscape so fractured, how do we move forward? How do we fight this new wave of artificial falsehoods? Well, it seems we're facing a fundamental choice between two very distinct paths.
Path number 1. We regulate the speech itself. This would mean going back and rethinking NYT versus Sullivan, maybe lowering that actual malice standard to make it easier for people to sue the creators and distributors of harmful lies. Path number 2. We regulate the tools. This approach would leave the strong speech protections of Sullivan in place, but it would go after the supply chain of AI, holding the developers of the models and the providers of the computing power responsible for how their tech gets used.
And this all leads to a final, profound question for an era where reality itself can be fabricated. Where do we place the burden? On the speaker who utters the lie, even if that risks chilling legitimate speech? Or on the creators of the incredibly powerful tools they use, even if that risks stifling innovation? There is no easy answer, but it's a choice our society has to confront, and soon.